Hello, class. This is Brianna Washington. I do apologize for my voice. I'm sick and I'm going to try to talk as loud as I can. This is presentation number 3. I'm doing my jurisdiction on Florida, and these are the top facts. Number 1, Jason and Mark was playing and drinking, and Jason dared Mark to punch him in the stomach, saying he could take it. Number 2, Mark said no at first. Then he pulled Jason's arm and then punches Jason in the face, breaks Jason's jaw, and knocks his teeth out. Now, the question is, can Mark argue that Jason gave him consent? And will the judge grant a motion to dismiss the lawsuit? Alright, so let's shoot over to Westlaw. I'm going to type in consent. Same paragraph as assault and battery. And I'm going to go to the key numbers so I can have an accurate search. And I'm going to go to defense consent. And the one in particular I'm going to look at is Hogan versus Tavel. And the head note states, one must give knowing consent for consent to be an effective legal defense to claim of battery. Consent is violated if it's procured by fraud or concealment. And this is the same case, and it's saying that the former wife's consent to sexual intercourse, if given without knowledge that former husband was infected with sexually transmitted disease of genital warts, was equivalent of no consent and would not be a defense to battery charge based on transmission of disease from husband to wife. In this particular case is talking about consent and battery. A second one that I chose, which I'm going to go back. Let's do consent, same paragraph. And let's do appearing. Assault and battery. See, it tell me if it's misplaced. Misplaced quotation or search term was previously. Okay, so consent, assault, and battery. And I'm gonna do, let's see, look up these cases. And let's try Lyons versus State. Lyons versus State, for assault and battery, consent is not a valid defense to criminal aggravated battery, and hence testimony related to consent is properly excluded. So in this case, it was excluded because consent is not a valid defense. So let's try something else. Let's put in implied consent. Same paragraph. In talks. Citation. I'm sorry, it might be spelled wrong, but Westlaw would give me the correct. Oh, it was right. Usually I spell it wrong. So I went to the key numbers. Grounds for test, consent, express or implied. Okay, let's go to this one. This sex offenses, consent, intoxication. Well, let's add something else. Let me add assault so it can be more accurate. Okay, let's go to the key numbers. Okay, consent. I see State versus Gonzalez again. Lines versus State. These are the ones that I used previously. So, State versus Gonzalez states that count against doctor charging aggravated battery upon patient during performance of abortion was properly dismissed where touching of a patient occurred during surgical procedure was consented to and complications were foreseeable. In all of these cases, all of them were dismissed because of the consent. And in the facts of this specific case, I will say that Mark, which one was it? Jason. Okay. Jason gave Mark, he consented him to hit him in his, punch him in the stomach. But he did not consent to him hitting him. But in a judge case, in a case that's going to court, I truly believe that it will be dismissed, considering that he did consent. He consented to him assaulting him in general, stomach or face. He consented to him assaulting him. So I believe if it did go to court, that it will be dismissed. The judge would dismiss it because as a whole, Jason did consent to Mark to assault him. So that's my view on the facts of this case. If anyone have any questions or concerns, or if you want to point out something to me that I did wrong, please feel free to let me know. Even if I did anything wrong in the terms and connectors, I do love feedback and criticism, so feel free to let me know. I will put the cases down at the bottom of the video. And thank you so much for watching.